Thank you, Chairman Langford. First, I'd like to recognize a great friend and a great legislator, Josh Boucher, who is from North Dakota and a great friend. I've known Josh for a long time, fairly long time, and while he's a tremendous legislator, he's an even better person. And I will tell you, one of the finest North Dakota could send here. So thanks so much, Josh, for making the trip. Someone who doesn't just talk about making things better, he rolls up his sleeve and goes to work. And I'm glad that he can be here today to talk about how North Dakota does things right there back home. So over the past 3 years, we've been leading this committee. We've spent a lot of time examining the regulatory process, from the basic framework of the rulemaking process to the doctrines that are applied in court to the nitty-gritty of how decisions are made on an agency level. From these examinations, legislations flowed, trying to adopt different ideas that's been discussed in those hearings. What we have not done enough of is look beyond the process in Washington. This hearing is a great way to learn about the activities of our partners in governance, the states, to learn about how they've tackled many of the same questions that we've considered in this committee, and to basically let the laboratories, the 50 laboratories of government, work and inform some of the practices that we do right here. If anyone's been following this committee, they know that frequently I ask about the intersection between federal regulation and state regulation, because a lot of the challenges that we have here for over-regulation or duplicative regulation or inconsistent regulation is really that push between state and local regulation and federal regulation. And a lot of us believe that if the state is already protecting public health and safety, that that's the level at which those institutions are most accountable. And so we definitely want to hear not only your opinion about what you do, but maybe some of the frustration about the duplication that you see in regulatory effort with federal regulation. And so with that, Mr. Chairman, congratulations. It's a great opportunity for us to learn a lot more about how things could work better and how we could work better with state regulators. This is always a challenge because there's two functions, right? There is the oversight function, which we as legislators all believe is absolutely critical. And there isn't any of us who have ever been legislators who haven't said, that's not what we intended. I don't know why they're doing it that way. I mean, it seemed clear when we passed it. Why isn't it clear to them? But on the other side is this question of separation of powers, and whether, in fact, the legislative branch being so critically involved and so strategically involved in regulatory analysis and potentially rewrite, that it flips over and results in a breach of that all-important separation of powers doctrine that is fundamental to state constitutions, fundamental to federal constitutions. So I want to explore kind of that line. And both of you, there's two of you who have basically said your states have confronted constitutional challenges. And the end result was a constitutional amendment in both cases, correct? In the case of Idaho and Connecticut. Can you just explain to me the various constitutional provisions you did enact, whether they were tailored very narrowly or whether it weighed on the side of greater participation of the legislature in implementation of legislation, or whether they really just help clarify what, in fact, was the oversight responsibility. And we'll start with you, Representative Bedke.
Bedke, ma'am. We were very careful in drafting the words in the constitutional amendment. I kind of glossed over that we passed it on the second try. What was such old hat for the legislature, if you will, turned out to be not, so in 2014, the voters narrowly disapproved the constitutional amendment, but there was zero explanation there. What, like I said, what seemed to be self-evident to us was obviously not to the general public. We then I headed up a statewide campaign to go to all the newspapers and all the media statewide and explain what we were doing. So we were very careful. We believed that the line that we did not want to cross was, we could accept or reject. And the wording says in whole or in part, but that in part meant subsections of the rule. So we stopped short of amending. We stopped short of, the Meade versus Arnell case upon which, which is the Idaho Supreme Court case, which was the basis for all this, was clear. And we attempted to just codify that ruling and not overreach because of all of the reasons that you stated earlier. So we were very careful not to cross that line, and we feel like we found the balance in there. Now, the executive branch through the governor objected to, came out with a campaign of his own, as did the state attorney general, saying that the legislature was overreaching. But we were very careful to delineate that line and not overstep. And we believe that it has resulted in the dynamic give and take that there needs to be at the state level. When the regulated public comes into the committee to testify about how it's affecting them, then their advocates are their elected officials, not the executive branch agency. And I mean no disparagement to those that work there, but they are not elected to represent the regulated public. And so that insertion of having the elected officials usher that, the regulated public through the rules, which are laws, we believe holds us accountable as elected officials and gives the citizens a voice in the process, rather than just passing vague laws, passing it off to the executive branch and wishing everybody good luck.
Representative O'Neill, can you just explain kind of the constitutional development of your process?
Sure. As I mentioned, we had a court case, Maloney versus Pack. Lower court said we were unconstitutional, what the committee did, and the Supreme Court overruled it, but as I said, on technical grounds. So the constitutionality issue was never really resolved by the Supreme Court. And so very shortly after that decision came down is when the constitutional amendment was passed by the legislature and voted for by the public. And what that did was say a couple of things, one of which was that we clearly had the right to delegate the lawmaking function if we chose to administrative agencies. And the second thing was we also had the power to review and, if need be, reject, disapprove the regulations that were adopted by the agency. It was a very short amendment. It was a broad grant of authority, really, to the legislature to pass laws to implement that constitutional provision. And so what it really did was, I believe, and was intended to do at the time, was to ratify the system that we had already created up until that point, and to allow for its further development, because it would be a clear constitutional basis for the committee to do what it was doing. And I think that's pretty much what it has done. It did not really change the way the committee was structured or the way the committee operated. I think
Just legitimized it.
I'm sorry?
Just legitimized it.
Just legitimized it.
I don't want to belabor this, but I want to explain the challenges that we have, because there are federal court cases that talk about so-called legislative vetoes, and whether that is in fact in violation of the continuum of responsibility under separation of powers. And so we don't have the luxury of a process that is very accessible for changing our Constitution. And so we have to make sure that when we're drawing those lines, that we're staying well on the side of legitimate oversight in terms of our legislative process. I, as a state agency head, both as Attorney General and as tax commissioner, spent a fair amount of time in front of the Administrative Rules Committee justifying the rules. I think that having that process, I will tell you honestly, made us much more conscious of our outreach, much more responsive to concerns, and maybe even resulted in amendments because we knew we were going to have that level of immediate accountability, not just judicial review, but legislative review. And so I'm someone who have seen that process work, both as an agency head and as somebody who fully participated. And so with that said, we're trying to figure out how your lessons, which seem to work really well in your states, how that can be kind of adapted and adopted here. One thing I will remark, it's interesting, in Idaho, I mean, you're basically a one-party government. I mean, there isn't a very robust second party in Idaho. That's not true of Connecticut. Obviously, governor frequently can be and is a Republican. You know, Idaho, I don't know when the last Democratic governor you had or Democratic Party legislator.
It was Cecil Landris, and you know, so it's been a while. But they're, of course, having a large majority party gives us the luxury of fighting amongst ourselves. So, and the Democrats, you know, the minority in Idaho they're not shrinking violets, and if I may. All of our state constitutions with regard to the Article 1 provisions in the United States Constitution, I mean, they read very similarly. And arguably, we have not let those Article 1 powers erode.
Except, in order to augment those Article 1 powers, you had to pass a constitutional amendment. Which is the point that I'm trying to make, which is you may not have had in Connecticut you know, you had a process, you were continuing that process under kind of color of authority. You clarified the authority. In your case, you responded to a critical and otherwise prohibitive court case. North Dakota, we haven't had that, in part, I think, because you haven't reversed a lot of rules. And so we're just trying to figure it out here. Can you, Representative O'Neill, can you talk a little bit, and I know I'm taking up some time, but I don't know, there's not a big, we're the nerds here, what can I tell you? Can you explain how you believe that the kind of party balance that you have in Connecticut affects your ability to do this work, or whether you see challenges?
Well, as I said, I think the bicameral, bipartisan nature of the committee helps it because there's not the sense that it's one party that, let's say the majority party also was the majority party on the committee, would give the sense that this is basically coming from a partisan perspective. One of the little watchwords, phrases that we sometimes hear is that the other party is the opposition, the executive branch is the enemy. So we kind of, and that's spoken by both Republicans and Democrats, because we all have similar experiences in trying to deal with an executive branch agency that's being recalcitrant. So I think that we have a very partisan system. I mean, we do things on a very partisan basis in Connecticut. I'm surprised at sometimes when I talk to people from other states that the partisanship is not as intense. We can be bipartisan as well. We have institutionalized it in some places, such as this committee. And it occasionally occurs that there will be a 7-7 split along party lines, but that's fairly rare. And so most of the time, the committee speaks with one voice. It is a unanimous decision, and the executive branch, whether it's the governor or some commissioner who's trying to do something, or the treasurer, because we review their regulations as well, and so on, gets the impression this is the entity that is speaking on behalf of the legislature as an entity.
I just want to make this point before I turn it over. I think some of the hesitation is this idea that the executive gets elected, different political party than the legislative branch, and therefore there's an automatic way that you can limit the ability of the executive, who is of a different political party, to actually make decisions that are executive in nature and really executive. What's interesting about your process, and we've been kind of chatting a little bit about it up here, is it really is about a legislative prerogative versus an executive prerogative, and building that support for the overreach in the executive. It's not a political thing. It really is a thing that challenges the relationship between legislative and executive regardless of party.
Yes, if I could just point out, in the years that I've been on the committee, we had a Democratic governor, Bill O'Neill, when I first got on. Lowell Weicker, former United States Senator, was governor as an independent for 4 years. We had Republicans, and then now we have a Democratic governor. And the relationship between the committee and the executive branch has been pretty much the same consistently throughout all those different people with their different political perspectives and so forth.
So,
I have a quick question. Have any of your states looked at judicial review and whether there had been a reversal of a lot of rules before your process, and whether in fact there's been a decline and probably maybe even an elimination of judicial reversal of regulations as a result of this process?
That's an interesting question, Senator, and I can have the research done, but I don't have a straight answer for you at this point.
Do off the top of your head, do you have any recollection at all of a recent, since your process, since the constitutional process went into effect, of the court voiding any rule that came through this process?
Keep in mind, we only elevated this to the Constitution last November.
Okay.
And so we have not had a challenge yet. But I believe that that new legislators are going to have to be careful with the wording that we used. And if we begin amending rules
You're in
rather than
trouble.
just accepting or rejecting, I believe, and I'm not a lawyer, and forgive me for bragging, I believe that there is a line out there over which we should not cross, but we have not been challenged yet. And of course, that was some of the assertions in the campaign leading up to the constitutional amendment, that this was going to be challenged and whatnot. But the opponents could not come up with a scenario that was not addressed in our process. Now, my friend from North Dakota has gone into great length the technical aspects of your state's process. We have a similar technical way that we do it all, and so the opponents that debated me, during the campaign leading up to this, we were able to go into depth and to allay those concerns in a way that allowed the process or the measure to pass with nearly 60% of the vote.
Yeah, I think one of the points that I'm trying to make is that listening to you all, we're worried about whether you're usurping executive authority, but you're almost acting like a first judicial review of the regulation. And so where we have focused on this separation of powers, a lot of what you're doing is what you would expect a court to do on the front end. And I'm just wondering if you've seen a reduction in the number of regulations that have been voided by the court because you've gone through this process.
yeah, let me add one thing to that. Now, I definitely want to hear this answer. The court has the responsibility in law to define what the law says. You're actually saying, no, this is what the law says, and you're not following it as a regulation. So that's why we're jumping into this. And we have lots of follow-up questions on this issue of judicial review, but let's keep going.
We've been at it so long, it's hard to tell in terms of challenges, other than the PAC decision where it was voided, or the committee's authority was challenged as unconstitutional at the lowercase court, and then later on was not, but that case was overturned but not resolved. We don't get a lot of court cases as far as I can tell. I certainly could go through and see if we can try to do a comparison. Things were so different in the way people would be able to go to court and challenge things back in the 60s, I would say, for regulations, before this committee really got rolling in the 70s, that it would be hard to do the comparison. I do know that periodically, when people do still challenge our regulations, we will hear, because we are told we have to subpoena all the records from the review committee's proceedings to bring to the court because they're challenging a regulation on the grounds that something is being done either inconsistent with what the committee told them to do and what the regulation was rewritten to say, or they're claiming somehow that there was something wrong with what the committee did. But that doesn't happen on a, as far as I can tell, a very regular basis. My impression is that most issues that would provoke a court action are resolved at the committee level. And it's certainly one of the things I think of the strong points of this process is that you can avoid unnecessary litigation because you've got someone who, on the bureaucracy side, who simply won't listen. So that's my impression. We don't get a lot, but we still do get some.
Okay.
And my recollection is, you know, we haven't had too many court cases, judicial cases related to this, but what I have seen, and I'd have to think of an example, I can't do it at the top of my head right now, is that advocates for a judicial change may go to an agency and say, can we make a change through the administrative rules process to
Wait,
stay out of court?
say that again.
We're advocates of a change, so instead of taking it to
So
court.
an outside citizen group,
Right.
okay?
Or a business entity, or, you know,
Right.
regulated community would go to the agency and say, instead of us doing this, can we come to compromise through the administrative rules process? And again, we haven't had a constitutional challenge, so that's unique, I think, compared to my colleagues here, but